otherwise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Welcome to FCPA Flash. This is Professor Mike Koehler. And in today's episode, I'm pleased to be joined by David Ogden. David is a partner in the Washington, D.C. office of WilmerHale and chair of the firm's Government and Regulatory Litigation Practice Group. Prior to this position, Mr. Ogden served as the DOJ Deputy Attorney General from 2009 to 2010. And prior to this was an Assistant Attorney General in the DOJ's Civil Division. Thank you for joining us today, Mr. Ogden.
Oh, you're very welcome, Mike. Thanks for having me.
Recently, you delivered a keynote address at a recent symposium titled The Enforcement Maze, Overcriminalization of American Enterprise, that was sponsored by the U.S. Chamber of Commerce Institute for Legal Reform and the National Association of Criminal Defense Lawyers. The speech was the focus of a recent FCPA Professor post earlier this month, and I highly encourage listeners to read that speech in its entirety. Now, in this speech, you criticize what you call the DOJ's leveraged-based enforcement approach. What were the origins or motivations for delivering this speech? And can you describe for the listener in greater detail what you mean by the DOJ's leverage-based enforcement approach?
Sure. Well, the motivation really was an evolutionary process of becoming concerned over the course of the last several years, really sort of increasingly concerned about what has seemed to me to be a shift in the way the government negotiates, and the Justice Department in particular, negotiates resolutions of potential criminal or civil enforcement matters. When I was running the Civil Division at DOJ in the 90s, which I did the last couple of years of the Clinton administration, one of the things that I became very impressed by was what seemed to me to be an extraordinarily serious fact and law-based approach that was taken in the resolution of both the civil and the criminal matters that I had under my direction, and I'm not taking credit for that. It seemed to me it was the ethos of the department to recognize that in resolving serious, grave charges of criminal or civil liability, particularly with corporate defendants, there was an ability that the government had, if it chose to exercise it, to compel really excessive outcomes, even potentially to force settlement of matters that didn't have a sufficient basis in fact or law, because there was such pressure on companies to put charges like that behind them, and that the government, instead of exercising that leverage, really exercised restraint. They went after the bad cases really hard and tried to work out resolutions, but there was a sensitivity to the fact that government needed to regulate itself because it had the ability to drive really excessive bargains. And what has seemed to me to have happened over the course of time since then is that sense of restraint has kind of departed for many, not all, government enforcement lawyers, prosecutors, and others. And we see increasingly in corporate matters enormous resolutions of cases that happen, and the numbers just are skyrocketing. We see the department increasingly bragging about the huge increase in resolutions of corporate enforcement matters in terms of the dollars, in terms of the numbers of outcomes. And my perception has been that this is really generated by a decision. I don't think any conscious decision or a memo went around, but I think a sort of a change in the culture of enforcement, in which the notion is, let's maximize outcomes, let's get as much money in these cases as we can, and essentially put the burden on the defendants to say no, instead of exercising responsibility and self-restraint. And I think what's concerned me about it was that not only is that unfair and a bad way to do law enforcement, but I think it's really contributed to an unfair a tarring of American business, that it is deeply corrupt, and that there's all these terrible things going on. I think there are bad things going on. There are crimes that need to be addressed, but I think in many cases the impression is given that criminal activity has taken place when lesser things have happened. And it's also harmed the government, because the Justice Department is never able in these cases, where it's driven these very extreme penalties, often with these early settlements, to actually convict an individual of crime, because the case just isn't there. And individuals don't plead, don't agree to charges in the same way corporations do. The government's put to its proof, and it typically fails, or more typically doesn't even try, because it doesn't have the evidence. And that hurts the government's reputation, because the public gets the impression that the government's letting people off, when in fact the government's creating that impression by driving these pleas and settlements that it really can't substantiate. So what I argue for, and what I to make the case for, is a return to that self-discipline of really insisting that you've got the facts, insisting that you've got the goods before you drive a settlement. Have that settlement match the severity of the crime, and then in those cases where you've got it, you should of course prosecute the individuals who were responsible. So the reason to give the speech was to make those points, and to urge an institution I really love and care about a lot, the Department of Justice, to return to the way it did business more frequently some time ago.
And it seems all very basic, as you've just articulated it there, and relating it specifically to the FCPA context, and picking up some portions of your speech, you write about these large dollar plea agreements that often include very weak evidence of mens rea, or very aggressive or unclear theories of liability and damages. And we see this a lot in the FCPA context. According to statistics I keep, approximately 75% of DOJ corporate FCPA resolutions never result in any individual charges. And what you said in your speech was that because of the leveraged settlement amounts and corporate pleas, and how they can be obtained despite weak factual predicates and uncertain legal grounds, the credible prosecutions of individuals on the same theories are often not practical, or if prosecutions are pursued, the government loses them.
Right.
Now, to anyone who values the rule of law, your informed observation there, I think is troubling, dare I say, even scandalous. How in the world did we get to this point? How did the U.S. criminal justice system in the year 2016 get to this point? Was it incremental? Was it just gradual? Was it explicit, or did it just sort of happen?
I don't think it's explicit at all. I think it has happened in part. Well, I think it's difficult. I'm not sure I'm qualified to say sort of definitively how it has happened. I think that we went from a circumstance in which the sense of discipline and law and fact-based enforcement, which in the exercise of self-restraint, has kind of given way to a different notion, the notion that really the government should drive the hardest bargain it can drive and shouldn't leave any money on the table. And if it can force somebody or some company to cough up a lot of money, it should do so. And it's leaving money on the table for taxpayers if it doesn't. And I think there's just been a slow erosion. I think to some extent we're increasingly operate in a world in which agencies and decision makers are required to sort of justify their existence by pointing to metrics, and dollars and numbers of plea agreements are easy to point to. I think awards get given to people who generate these big outcomes. I think leaders like to take credit for the big numbers that are out there, for the efficiency with which they produce big numbers. I think it makes for good headlines. So I think there's all of that. I don't think anybody's necessarily setting out directly to say, well, let's get some weak outcomes in order to drive the numbers. But I think that it has contributed to a lessening of self-discipline, and folks feel they're going to succeed, I think, within the system if they drive these big numbers. And I think there's a sense maybe that that's a better way to be viewed favorably than making a decision not to prosecute, or a decision to take less because more isn't justified. So I think it's been incremental, and I think it's not a question necessarily of anything sinister, but I think we've seen a shift, and I think the outcome is really a denigration and a loss of the rule of law. And that's why I felt it was important to remind the department that really what they should be focused on is producing a high quality of justice and a just outcome, and that'll benefit them, because they will be getting outcomes that comport with the facts, and they'll be getting criminal convictions of people who are responsible, and not creating this impression that bad people are getting away with things, which is, I think, the current sense of things.
Now, a portion of your speech talks about the practical realities that business organizations face in this current climate. And you say in your speech, quote, the business organizations will push back in negotiations and develop their defenses, of course, but in the end, the pressures to capitulate and seek the best deal they can are hydraulic. Unpacking the elements of the leverage, there is the simple fact of potential indictment or other public disclosure of an investigation, each of which can have a harmful impact on a company regardless of the ultimate resolution of the case. Now, my read of that excerpt there was that you were perhaps implicitly referring to what's been called the Arthur Andersen effect, the notion that a company can't risk a criminal indictment, can't fight back against the DOJ because it would spell the death of that company. What is your response to the assertion, though, that the Arthur Andersen effect is sort of a debunked myth? And does the recent example of FedEx, who was criminally charged by the Department of Justice a couple of years ago and recently prevailed over the DOJ in a criminal trial, does that spell the death of the Arthur Andersen effect? Does that send a signal to corporate boards and other decision makers that, you know what, if you do disagree, there is an option of fighting back?
Yeah, well, I think often there is an option there, and I think the Arthur Andersen case is sort of the extreme cautionary tale at one end of the spectrum, where an indictment spells the doom of a company. And I think there are circumstances in which certain kinds of institutions, Arthur Andersen, an accounting firm, is one, that where you see that certain kinds of charges against certain kinds of institutions really can't be resisted because the mere bringing of the charge undermines public confidence and customers' confidence to such a degree that they won't survive the charge itself. In other circumstances, and perhaps FedEx was one, the company looked at the nature of the charges and the nature of their business and said, look, we can fight this one and win it. But in between that, there's an enormous range, and I think the reality is that for most companies, finding themselves in a situation where serious charges that will damage their reputation simply by their announcement and will create fear about the company's long-term survivability if they should lose a case, will see it as highly valuable to get a resolution of that matter, even where they don't think the charges themselves are particularly strong, and they think they've got a good chance of winning. Number one, you roll the dice and lose. I mean, FedEx rolled the dice and won. In certain kinds of cases, you roll the dice and lose. The size of the penalties that can be imposed and that sometimes must be imposed are so enormous they may not be survivable, or may be at least a massive hit to the company's profitability. Number two, just the reputational injury, the harms in the capital markets, are huge disincentives to sort of labor under that until you ultimately prevail. And of course, you might not, even if it's a 10% chance of a devastating outcome. That's terrible. And then further, there are collateral effects, such as debarment and the like, that raise the stakes. So yeah, you can roll the dice. If you roll the dice, and sometimes you can't afford to roll the dice. Sometimes if you roll the dice and they come up snake eyes, you're not going to survive it. And so, sure, I mean, the fact that companies can litigate many of these cases and win, that is certainly true. But it's also certainly true that there are enormous pressure. There's a lot of leverage that the government has because the mere bringing of a criminal charge for a company or a person is a terrible thing to happen, and the pendency of those charges has very real and concrete effects and raises risks that are sometimes really very, very hard to sustain. And if you can negotiate something and get it behind you, very often the company's stock will rise, reflecting an evaluation that they've done something good, even if they've paid a lot of money. So the Arthur Andersen, as I say, that's the extreme case, but it doesn't mean, and the fact that some companies can win when they do challenge a prosecution, doesn't mean that there aren't enormous pressures on companies in the typical circumstances to capitulate, regardless of the strength of the charges against them.
Yeah, difficult decisions, to be sure, that face general counsel and corporate boards in these types of situations. You mentioned
right.
debarment, and that was also a focus of your speech, and the notion that criminal penalties may not even provide the most leverage to the DOJ. Instead, you spoke that the threat of debarment or exclusion often provides the biggest stick. To be sure, this is a huge concern for certain companies and certain industries, but here isn't the solution to the problem perhaps to take a closer look at the actual debarment and exclusion policies that different federal or state agencies have? In other words, isn't the problem here not necessarily of the DOJ or the corporations making, but politicians and bureaucrats passing or enacting politically popular but oftentimes nonsensical debarment and exclusion regulations?
Yes, and I think that's part of the problem. And one of the proposals that I made in my speech, and certainly one of the things I believe, is that part of the cause, part of the excessive leverage that exists is that the rule set that governs in these circumstances is often nonsensical and politically driven, and I think the penalty structure for many of the offenses that are at issue and the exclusion and debarment rules don't make a lot of sense, and that creates the opportunity for enforcement officials to leverage unjust outcomes because the company is negotiating against a completely unacceptable potential endpoint, an irrational but still authorized by law result. So that causes this need. So I say, yes, one thing we need to do is change the rules. But politically motivated and unfair potential penalties are probably always going to be with us because I think those kinds of pressures exist. They certainly always have been with us. And it's because there is such a range of potential punishment, because there are very extreme outcomes that might be authorized in some cases, might even make sense in some cases. But it's because that discretion exists that historically prosecutors had to exercise restraint and say, we're not going to take it to that end. We're going to have principled rules that protect against those kinds of outcomes. And it's the need for that discretion in the face of those extreme potential penalties that the department historically exercised and met that need, and now I think is increasingly walking away from and going ahead and using the threat of those irrational outcomes to generate these big resolutions. And while I totally would support your notion that, yes, let's take a look at the potential penalties and have as rational an approach to exclusion, to debarment, to civil monetary penalties and the like as we can, but I think we also need to recognize that there's a fundamental obligation that prosecutors in the department have to do justice in every case, and to recognize that extreme irrational outcomes really shouldn't be something the government's trying to bring about.
One of the things I particularly liked in your speech was your suggestion that this leverage-based enforcement approach that the DOJ is using is actually hurting the government in many respects. And you said in your speech, quote, "It only stands to reason that if companies fear, based on experience, that the government is likely to use every point of leverage to drive highly punitive outcomes, the companies, will be less willing to disclose violations to the government."
Right.
Can you elaborate on this point, particularly in light of the FCPA pilot program that was announced by the Department of Justice in April that had as one of its policy goals to encourage more voluntary disclosure by companies?
Right. Well, I'm a big believer in the idea that really the way government and the law should think about organizing itself in this realm to maximize the incentives for companies to do the right thing. I think companies generally share the government's interest in having a being law-abiding, and in having a marketplace that operates consistent with the law. And I think that the government should be doing what it can, first of all, to incentivize the best kinds of compliance programs, and second, to incentivize appropriate cooperative behavior when a violation of law does occur. As you know, in any human institution, there are going to be violations of law, whether that's a company, whether that's a government, whether that's a nonprofit entity. These things happen, and what you want is for the institution to respond in a way that's consistent with the law. And I think that a highly punitive and frankly unfair enforcement structure disincentivizes all of that, because in order to feel it's rational and in one's self-interest to cooperate, one has to think that the result of that will be a balanced, appropriate outcome. Not that you'll get a free ride, or that necessarily that you're going to be let off the hook because you cooperated, but that the outcome is going to make sense, and that the fact that you were cooperative is going to be recognized significantly in the outcome. And I think the idea of the pilot program is consistent with all of that. I think the challenge becomes the benefits need to be clear, they need to be predictable, and one of the problems in general with the idea that cooperation begets some benefit, that you're going to be benefited by cooperating. People have said, the government's taken that position for years. It needs to be clear and predictable so that people within the company will recognize, yes, this is the right thing. Not only is it the right thing to do morally, not only is it the right thing to do, for reasons of good citizenship, but actually it's the right thing to do for the company and for the shareholders. It goes, similarly, the department's current heavy focus on companies disclosing wrongdoing by individuals, or conduct that might be viewed as wrongdoing by individuals with a company. I think that's also something companies should do, and that the government should be encouraging appropriately. But if businesses believe that the government is going to go after people who didn't do something wrong, they're going to be much less inclined to cooperate than they would if they think the government is only going to pursue righteous cases. And so that trust, the government needs companies to trust it to act fairly in order to have companies feel that the government merits their cooperation, or that it's in their interest to cooperate. So, my view, and what I was trying to explain, was that I think the government benefits, as all of us do, when it is disciplined in its use of criminal and civil enforcement tools, when it only pursues cases, that it has a sound and clear theory of liability, that it only seeks pleas and enforcement outcomes, when it has the facts, and when the elements of the offense, including the mental elements, the intent elements, are satisfied. When those things exist, it should enforce the law in an appropriate way and seek an appropriate penalty that brings about deterrence, that brings about accountability. It should make individuals accountable. But when it stretches and when it uses every point of leverage, whether it be against companies or against individuals, it damages its own reputation. It induces the private sector take an adversarial approach instead of a cooperative approach. And so that's why, it seems to me everybody wins if we go back to this idea that it's justice and fairness that should govern the enforcement of the law rather than maximizing the number of pleas and the size of settlements.
Yeah, again, that all sounds so basic and elementary that it's hard to disagree with anything that you said. And having a person of your position and experience make those comments and feel like the current DOJ policies are not satisfying, that I think is very telling. My last question sort of goes to the conclusion of your speech, in which you chart a way forward, and you make various proposals such as limits on potential penalties and coordinating often redundant investigations by multiple agencies. If I may, missing from your proposal is indeed one I've long advocated for, and I'd appreciate to hear your thoughts on this, and that is abolishing MPAs and DPAs altogether. Now, after all, many of the problems you rightly identify in your speech, whether causally related or merely coincidental, occurred at the same general time frame when the DOJ, and again this is in the FCPA context, first started using MPAs and DPAs around 2004-ish. And in calling for an abolition of MPAs and DPAs, it's not like one is calling for an abolition to a long-standing feature of U.S. law enforcement, but rather I think what is accurately called a recent experiment. So the question, I guess, is would some of the excessive leverage that concerns you, would that leverage really be removed if the DOJ simply went back to the historical, what I've called binary option of charging versus not charging, that guided DOJ law enforcement for really nearly all of our nation's history?
If I may, let me I come to that because I know this is something that you've been very focused on, and I think it's an interesting issue. I wanted to say one thing sort of connected to the last issue we were discussing, which is kind of, and sort of more globally about this sort of question of outcomes. I mean, one of the dangers of giving a speech like this is the sort of the fear of oversimplification to some extent of your remarks. And one of the things I tried to emphasize in this speech was that I am talking about what I feel is a movement along a spectrum. I think there are many in the department who still do it the right way. And, I really think the key element of, that what policy needs to be in the department is encouraging that historical approach that many prosecutors still follow of discipline and close attention to facts and law and to fair outcomes, and to discouraging this increasing phenomenon that I think is driving these numbers. And I think it would be unfair not to recognize that so many still in the department do it the right way, and I think the key is for those people to be encouraged and for others to follow that example. I do think the non-prosecution agreements and deferred prosecution agreements, they're an interesting feature on the landscape. I think you're right that certainly their increasing use coincides with this phenomenon that we're describing. I think what I would not personally favor their abolition. I don't think they give rise to the leverage. I think what they afford is a less punitive place for the leverage to land. I think they reflect a recognition that, look, there are some cases in which there has been wrongdoing that's taken place, but that for one reason or another the behavior of the company is such that a lesser resolution rather than a full-blown plea or criminal prosecution is appropriate. And I think there are circumstances where that's an appropriate outcome, and the fact that non-prosecution and deferred prosecution agreements may end up happening in some of these cases that I'm talking about doesn't mean necessarily the device is a bad one any more than it's a bad idea to have plea agreements. I think it's an outcome which companies may resist less, and it may therefore be easier to push them into, in a sense, but on the other hand, they may be appropriate resolutions that a properly functioning department and a properly motivated and disciplined prosecutor might appropriately arrive at. So I would be reluctant to take those options off the table, recognizing your point that there may be less resistance to them, and therefore more discipline may be required in using them. What I really think is needed is a return to this kind of discipline that I was talking about, where in addition to sort of structural changes like addressing inappropriate penalties and, as you were saying, rationalizing exclusion and debarment rules to try to discipline the use of discretion, but that we recognize in the end there's going to be discretion, there are going to be a range of potential outcomes and matters, and that what's really needed is to ensure that those who are entrusted with that discretion exercise it for the proper reasons, and that they're rewarded when they make the right decision not to pursue a case or to take something less because it's the right answer, as much as they're rewarded for securing a major conviction in a case where that's appropriate. And I think that's a job for the leadership of the department. I think that's a job for those of us who care about the department to say, look, this is fundamental to the department's mission: facts and law, discipline and restraint in seeking proportionate and appropriate outcomes. And I really do think that it's that culture, that mindset, to me, has characterized the department in its much of its life, and still characterizes a good deal of the department, that we should be really focused on.
Well, thanks for joining us, Dave. The DOJ obviously has a very important job to do, and when it does act, it has broad-ranging consequences, and I think your speech was excellent in highlighting perhaps some of the policy issues associated with how the DOJ is currently going about its job. Again, Mr. Ogden's speech is linked to on FCPA Professor, and I highly encourage you to read the speech for yourself. So thanks for taking the time with our listeners today to elaborate on the speech.
Well, thanks for having me on, Mike.